All right, welcome everyone. Thank you for joining us in this place we call momentous, a place that has traditionally been a meeting place, a place of shared stories, connection, and learning. My name is Amy. I'm the Outreach and Communication Specialist at AWA, or one of them. I would like to take a moment to acknowledge this place we gather tonight as the ancestral home of the Treaty 7 signatories, which includes the Blackfoot Confederacy, comprised of Siksika, the Piikani, and the Kainai First Nation, the Tsuut'ina First Nation, and the Stoney Nakoda, including Chiniki, Bearspaw, and Goodstoney First Nations, as well as within the Métis Nation homeland. As a provincial organization, we serve the entire province of Alberta, which also includes Treaties 4, 6, 8, and 10. We express gratitude and respect for these lands and commit to advancing reconciliation with Indigenous peoples to ensure justice, equality, and sustainability for all people and the natural world we rely on. I want to welcome and introduce our speakers this evening. So the presentation will start with Carolyn Campbell, an AWA volunteer and former conservation director of AWA, where she worked for 16 years until retiring in 2023. Online, we'll welcome Beaver Lake Cree Nation's Crystal and Lameman and Beaver Lake Cree Nation's lawyer, Karey Brooks. Crystal is a mother of two and a proud member of the Beaver Lake Cree Nation, where she has held the position of government relations advisor and treaty coordinator for a decade. Karey is a partner at JFK Law, LLP, and she is the lead lawyer for Beaver Lake Cree Nation's Defend the Treaties lawsuit. So with that, Carolyn, I'll let you take it away.
Thank you so much, Amy. Hello, a special hello to Crystal and Karey. I'm so pleased to be here on the program with you. And thanks for everyone for being here. I'm going to start by saying that I am not Indigenous. My ancestors benefited from colonial practices that were harmful to Indigenous peoples, and I did too, growing up with many privileges in Calgary on Treaty 7 lands. Also, I don't speak for any Indigenous peoples. I learned of these initiatives that I'm going to talk about working at AWA. I'm giving you my understanding, which is incomplete in the short time that we have together. First Nations in what's now Alberta signed treaties with the Crown. Treaty rights are constitutionally protected, and as these land use initiatives show, they reflect living relationships and responsibilities, not a past surrender of practically all lands and cultures. Before our Beaver Lake Cree Nation guests describe their claim, I'll summarize two recent innovative land use agreements on Treaty 8 lands. One will be in Northeast Alberta and the other in Northeast BC. Both arose from successful lawsuits, but I want to emphasize that at the center are Indigenous people who are upholding their rights and their relationships with lands, waters, and other living things on their traditional territories. Here's Alberta's oil sands area, about the size of Florida. I've circled in red the first area we're looking into, near the heavily leased surface mineable area. Fort McKay First Nations traditional lands are severely affected by Alberta oil sands development. We see their main settlement on the Athabasca River, which is circled on the right in every map on the east, and their comparatively intact Moose Lake reserves circled on the left. From the first oil sands mine in 1967, we see that by 2015, their main settlement is surrounded by existing and approved projects, which are green, plus red planned projects, plus orange existing linear disturbance related to expanding exploration and production, including extending near the Moose Lake reserves. Since 2003, Fort McKay First Nation was discussing with Alberta government the need to manage cumulative effects in the so-called broader Moose Lake area. That's its western traditional territory shown in the black outlined area, which is quite large. And then as a kind of magnification, we see this red oval line, more of a close-up. And it's that red oval area that was particularly important. The Moose Lake Reserve lands and a surrounding 10-kilometer buffer area, they insisted needed to remain a place for wildlife, clean air, and clean water where they could exercise their traditional land use rights and ensure clean source water for their main reserve. The last straw was the Alberta Energy Regulator's 2018 approval of an in situ oil sands project, which requires lots of disturbance and a small refinery-like central processing facility. That was going to be within 5 kilometers of Moose Lake reserves, and the nation filed a lawsuit. In 2020, the Alberta Court of Appeal overturned AER's approval of Prosper Rigel Oil Sands Project, stating Alberta took an unreasonably narrow view of the public interest, particularly given reconciliation, emphasizing the honor of the Crown, cumulative effects of development, and that it was not honorable to cause Fort McKay First Nations treaty rights to careen into oblivion. So significantly, because of that successful legal claim, the Moose Lake Access Management Plan was finalized between the Alberta government and Fort McKay First Nation in early 2021. Now it applies to that oval red zone we saw earlier. It's only about 1,000 square kilometers in area. So we're talking relatively small part of Alberta, but I'm going into a little bit of detail on it because it's a really notable approach on Alberta public lands. Its 3 goals you see here: Indigenous, traditional land use and cultural rights, ecological integrity, and opportunity for responsibly managed resource development. And there will be no central processing facilities permitted within this 10-kilometer zone. Okay, for the interior habitat, this I think of as one of the kind of centerpieces of the access management plan. So for the ecological integrity goal, the management plan uses clear, innovative rules, and it recognizes there are cumulative radiating edge effects that lead from particular industrial land disturbance features which degrade habitat beyond those features and therefore affect traditional land uses and cultural practices. So development features under the access plan are mapped, then buffered by 50 to 200 meters for their edge effects. That's the disturbance impact areas you see in the light blue, just illustration. And the interior habitat, what's left, the yellow area, that's a proxy for intact habitat, biodiversity, so important for exercise of rights. The goal is to keep 85% as interior habitat. In other words, no more than 15% buffered disturbance. Basically, right now it's at 13.5% disturbance or 86.5% intact. So industry has the opportunity, not the necessity, but the opportunity for further disturbance. And another really neat thing about the access management plan is it actually allocates that total disturbance allowance among specific industries: forestry, oil, gas, sand, gravel. That's unusual and it's good because it helps sectors to plan. Also, buffers placed on industrial disturbance features can shrink as you meet recovery milestones from restoration reclamation. Also good because it really motivates operators to do well on that so that they are within their allowance. So these regulatory tools had been available, but it's still a real landmark for Alberta to have used them to manage public lands in this area. Moving forwards for Moose Lake, I learned in recent months from Fort McKay First Nation reps about the plan's implementation. For governance, there's now a technical advisory committee that includes industry reps. They've made a work plan for water and wetlands. In order to protect the nation's drinking water source, they will model groundwater, surface water, water interactions in detail and monitor for industry impacts. They'll map wetlands now to try to prevent destruction and promote avoidance. These are important biodiversity hotspots, and they will map and prioritize and restore linear disturbances such as seismic lines that aren't returning to native vegetation, and that part's Alberta government funded. They're discussing with community members which access routes to keep, how to minimize their impacts, and then overall, they're going to monitor and update the data on buffered land disturbance levels. So I believe that similar firm and insightful regulatory approaches for biodiversity and Indigenous rights should be implemented and could be more broadly in Alberta. Okay, now we'll go to the Northeast BC. I'll make some broad points. I was fairly detailed on aspects of Moose Lake, but I'll make some broad points about Blueberry River First Nations treaty rights lawsuit against BC and early results, again with an eye to Alberta. So this map is Blueberry River First Nations civil claim area, which is their traditional territory of some 38,000 square kilometers in the Upper Peace River region of Northeast BC. It's very heavily affected by fracking-based oil and gas production and intensifying forestry. Their lawsuit was filed in 2015. Yehi was the nation's chief at the time, and it was to stop the ongoing degradation of their traditional territory and protect and enforce their Treaty 8 rights against cumulative impacts of Crown-authorized activities on their traditional territory. In 2021, the BC Supreme Court ruled that the province's authorizations had indeed infringed the First Nations Treaty 8 rights, and the cumulative impacts had left insufficient areas to meaningfully exercise their treaty rights. The court also commented that the province's land use processes and decisions are inadequate. For example, they weren't adequately assessing what even were the cumulative development impacts on the exercise of treaty rights. The court ordered a revised land management agreement to be negotiated, integrating cumulative effects. And I say, Alberta, take note. BC did not appeal this decision. Instead, they moved forward, and by January 2023, they announced they had negotiated a consensus document, which is like a framework with 6 of the 8 Treaty 8 nations. And they'd also reached bilateral BC and First Nation implementation agreements with Blueberry River First Nations and 4 other nations. The potential area that's being remanaged because BC realized that there's interlocking land uses, and this was a decision about Treaty 8 lands. So the potential area being remanaged is really significant. All BC Treaty 8 lands potentially could be remanaged to uphold treaty rights. And that's an area 8 times Blueberry River's own claim area. So the tenacity of one First Nations can really have broader impacts. Okay, this is just an illustration of one important part of the consensus document, and it shows a zonation approach. So because this is a much bigger area, we don't have the buffering of disturbance features approach here, like with Moose Lake, but it's rather a zonation where some areas immediately receive permanent protection from new petroleum and natural gas activities and forestry. Others have interim rules to reduce new disturbance. And meanwhile, that gives time for multiple watershed level land use plans to be developed within the next several years that will assess and manage cumulative effects. There is a promise to have collaborative management of wildlife populations and habitat, and working towards co-management between BC and the nations. Now that language suggests some key shifts in decision-making, which used to exclude First Nations. Here's part of Blueberry River's bilateral implementation agreement. In order to balance responsible development with the protection and practice of their treaty rights, they identified critical cultural areas, also called high value or HV areas, that will be partly managed by capping the new disturbance rate of oil and gas development. And there's also some important forestry improvements in priority areas to improve biodiversity, there will be well-defined targets to increase old forest areas using forest reserve networks of various size and duration. And I want to emphasize each First Nation would be distinct in how they want to approach the balancing of cumulative effects management, exercise of traditional land uses, and responsible development. So I've just given these examples just so that we know that these things are possible. These new arrangements and relationships will have and have had some challenges, but the key thing is the past project by project authorization approach without any real cumulative effects management that BC used to practice with First Nations on the outside in Treaty 8 land, on Treaty 8 lands has been declared unacceptable and an infringement of their constitutionally protected treaty rights. And again, I say, Alberta, take note. With that, I want to thank you very much, and I want to invite Crystal and Karey to start.
Thank you so much, Carolyn, for that. And I think between Crystal and I, I'm going to kick things off. My name is Karey Brooks, and I am an Indigenous rights litigator. I've been doing this work for about 22 years now, and I've been working on this case in particular with Beaver Lake Cree Nation for about 10 years. And I want to thank the Alberta Wilderness Association for hosting us today. It's always a pleasure to be able to talk about this case, and alongside my my client and my colleague, Crystal Lameman, who's the litigation representative on this file. And the work that she's done is enormous on this file. And so we've been working together now for 10 years, and I've learned so much from her. But she really has poured her heart and soul into this litigation, and the effort from Alberta and Canada and really grinding the nation. I'm going to get into that, but has been very intense. So, Carolyn, well, I really appreciate you kicking things off in such an optimistic way and talking about some of the solutions that are out there. My presentation is a little more gloomy, and I'm going to speak to the effort that it actually takes to get to some of these places that Carolyn has highlighted is possible. So yeah, there's a slide presentation, and thank you to whoever is going to be controlling the slides, and I'll just let you know when you can advance to the next slide, which you can do right now. And just so folks know, we don't have a view of the audience, so I can't see you or interact with you. So if someone is waving their hand or has a question, somebody hopefully will alert me to that. But let's start with this. So Beaver Lake Cree Nation brought this action, treaty infringement action, in 2008. And just to situate you, the First Nation is located around Lac La Biche area in Alberta. It has about 1,600 members, and 500 of them live on reserve. And they did file this lawsuit 17 years ago. And it claims that the cultural and way of life rights that are guaranteed in Treaty 6 and include the rights to hunt, fish, trap, and gather have been infringed by extensive industrial activity in their traditional lands. And so in this presentation, I want to give you some insight into how these cases are brought, why they're brought, and what it actually takes to litigate and enforce treaty rights of this kind. And I'm also going to touch on why it's taken so long to get to trial, and I'll discuss some of the access to justice concerns that are related to that delay. If you could go to the next slide, please. So the claim was filed under the leadership of the late Chief Al Lameman, and sadly he passed away in 2022 at the age of 79. So he will never get to see the justice from the case that he very courageously brought now over 17 years ago. But during my time as counsel on this file since 2015, I did develop a very close relationship with him, and I really learned a tremendous amount from him. He was a huge advocate for this litigation. I visited his home many times, and we talked about the case and what led to it, and he provided guidance on how to manage the case in a good way. And he really had an extraordinary life story of growing up on the trap line at Beaver Lake. And he told me things like it was a hard life, but a good life. And he repeatedly emphasized to me that Beaver Lake Cree people were free. And he told me that over time, though, the government took more control over their lives, and there was an increasing concern about the loss of their culture and their traditional ways of life. And he talked about how industrial development was effectively assimilating Beaver Lake Cree people by transforming their traditional lands. And he was deeply committed to reversing that and enforcing this core promise in the treaty, the right to a unique culture and a unique way of life. And as I say, it's very tragic that Al will not see justice from this case that he started for his community because of the delay in getting it to trial. And that's one of the tragedies of delay in having these cases take so long to get heard. But as I stated, and if you could go to the next slide, please, the claim arose from real concerns about development on the community's traditional lands. And at the time the case was filed in 2008, there were about 20,000 different Crown authorizations for various projects, from in situ oil sands projects, forestry, agriculture, roads, seismic lines, other types of infrastructure. And the community was voicing deep worries about the development and how it was negatively impacting their ability to engage in their traditional land-based activities. So they highlighted declining wildlife. There were fewer animals available for hunting and trapping. Many of the animals often appeared sick. Their traditional berry picking areas were diminishing, and this was leading to an important loss of a food source. There were fewer places to go and practice their land-based activities like hunting and fishing and gathering. The significant cultural sites that had for many generations served as important gathering spots were lost. Trap lines were taken away, and their livelihoods were being severely disrupted. There was one particular event in the 1950s that created an enormous issue too, which was a bombing range for military practice was created in the middle of their traditional lands, and that displaced many trapline holders and had a rippling effect on families and the community. And it made about 20% of their traditional lands completely inaccessible to them. So all of this was contributing to this growing sense of cultural disconnection. And that's what was leading to this case being filed. Now, I do want to talk about consultation, and if you could turn to the next slide, because the case was brought out of a concern not only for the development that was occurring in the area, but also out of concern that the Crown had failed and was continuing to fail to consult and about that development that was taking place in their traditional lands. And as Carolyn mentioned, the Crown has a very narrow understanding of consultation. It relies on site-specific impacts. And so in project specific consultation, the Crown doesn't consider the totality of the land and resource base in deciding whether to approve the development. So it's not trying to determine what's needed by the First Nation in terms of how much quality land and resources are available, and in a cumulative sense. And it didn't do this in 2008 when the claim was filed, and its current land use planning frameworks now also do not do this effectively. But I think it is worth noting on this point that the timing of this claim, so it was filed in 2008, and this was at a period when treaty nations were increasingly advocating for government consultation regarding impacts to their treaty rights. So in 2005, there was a Supreme Court decision called McKay. And if you aren't familiar with that case, I'll just briefly touch on it because it's really foundational to this claim. McKay involved the building of a winter road through Wood Buffalo National Park. It was first through the nation's reserve and then went around it. But the McKay Cree Nation opposed the road, and they said that the road itself was an infringement on their hunting and trapping rights under the treaty. And in terms of consultation, the Crown had only provided the standard information. They invited the First Nation to general public meetings, and there wasn't any direct consultation on their routing decisions. Now, with respect to the nation's claim that the road itself was an infringement of their treaty rights, they were initially successful at trial. And then the Federal Court of Appeal later overturned that decision and said there was no consultation obligation. And then the case went to the Supreme Court, and it's the leading case now on consultation and treaty infringement. But like at trial, at the Supreme Court, the nation argued that, look, any authorization by the Crown is an infringement, and so it demands consultation. And and the government argued, well, actually, under the treaty, we have express authorization to take up land. And so therefore consultation is not required because we're granted that authorization under the treaty. And the court really kind of split the baby on this one and said not every authorization is an infringement. However, if you're going to adversely or potentially adversely affect treaty rights, then you must consult. And so this established the duty to consult on adverse effects as an enforceable legal obligation. And so this ruling was very significant. Before then, the Crown's approach to consultation was basically non-existent. Most developments proceeded without any engagement from Indigenous communities. And the Crown took the position that it wasn't required to consult when it was taking up land. So McKay clarified that consultation is necessary when there's a potential for adverse effects on treaty rights. But for the purpose of this case, the question is, well, when is a treaty right infringed? So the Crown can take up rights, but it must consult and minimize the impact to the right. But when would there be an infringement of a treaty right? And the court in McKay commented on that as well. And the court said that when the nation is left with no meaningful right to hunt, that could warrant a claim of treaty infringement. And the court makes this comment in one of the paragraphs, paragraph 48 of its decision, that if there comes a time when there's no meaningful right left to hunt, then that would constitute an infringement, and the Crown would be required to justify its actions, and the justification test is very high. So it was on that basis, that particular line in 2005 from the Supreme Court of Canada that says if there's a time when the right to hunt is no longer meaningful, that might be an infringement, and Beaver Lake brought its claim on that basis. If you could go to the next slide, please. So in 2008, Beaver Lake said the Crown has crossed over that infringement line, and that essential promise of the treaty, the promise to a way of life and a culture, was broken. And that began this very novel piece of litigation. So the action was based on this robust understanding of what Treaty 6 promised, that it promises a culture and a way of life, and that it's based on an infringement, that there's too much development interfering with the meaningful exercise of those way of life rights. And it was based on the fact that Beaver Lake Cree Nation was losing its culture and way of life because of too much development. It was filed against Canada because of its authorization of and taking away or taking up the Cold Lake Air Weapons Range, and against Alberta because Alberta had authorized the taking away of land from forestry and oil sands development, roads, and settlement. But it was the first case of its kind in Canada. And it was then and still is now an open question, legal question about the essential promise of Treaty 6. So we have some guidelines from the Blueberry River decision that Carolyn referred to, that Treaty 8 promises a way of life. And the court has yet to give a ruling on the meaning of Treaty 6. So this case will do that. And the Crown, of course, maintains that the treaty does not promise a unique way of life that would include things like preferred species, preferred places, preferred methods. Rather, the Crown's view is that if there's something to hunt somewhere, then the right is maintained. And Beaver Lake takes a much different perspective and says the treaty is intended to protect the unique way of life, and it provides these additional benefits in exchange for sharing the land. That Indigenous peoples were promised they were giving up nothing. They were told that they could hunt and fish and carry out their way of life as before, with the Queen's gift in addition. And so this case is really going to dive into these different perspectives and understandings of the treaty. And the court will have to look at, did the treaty promise, in promising a way of life, that there would be a certain quality and quantity of land available for the meaningful exercise of rights? And if it did make that commitment, or that follows from the commitments it made, then how much land and resources are actually needed to sustain a meaningful practice and a meaningful exercise of rights? And what should the Crown be doing to understand how much is needed and make decisions about how land should be used? How should the Crown take into account the exercise of rights on a territory-wide basis when it's approving development? So as Carolyn said, we do have a significant court decision from BC on this in a similar context, dealing with Treaty 8 issues. And in that case, the BC Crown, as Carolyn pointed out, didn't appeal. They also didn't even attempt to justify the infringement. So they focused their argument solely on denying that the treaty made those types of promises, and that they said Blueberry members could still meaningfully exercise their rights. So they argued that the right was really very narrow. It was limited to hunting and fishing, and that it could be essentially until the line doesn't get crossed until there's no right left at all. And we put the line, further. We moved the goalpost to say that meaningful is the key part of the test. That the right has to be meaningful, not no right at all. But our case will be really different than what happened in BC. As I say, BC didn't even attempt to justify the infringement. Canada and Alberta will mount a very strong justification defense based on economic need and their consultation processes, their land use management processes. So we're going to see an entirely different approach to defending the case than what was seen in Blueberry. So let me just talk about now the steps in the litigation since it was filed in 2008. So there was initially, because it was a novel case, right out of the gate, the Crown tried to have it struck completely. to say it was not justiciable. The Crown said it's too novel, it's too complex. Developments allowed under the treaty. The case has no merit. They said it's abusive. These authorizations have been allowed. There's been no prior objections to it. And those motions to have the claim dismissed on that basis took 5 years to resolve. It went to the Court of Appeal, and the applications themselves were very expensive. They cost just the nation over $1 million to deal with those motions. Ultimately, Beaver Lake was successful, and and the court said at the end in 2014 that the party would be best served by advancing this case to trial and essentially get on with it. But by that time, Beaver Lake did not have the funds to continue with its action. It worked very hard to raise funds. Litigation like this costs millions and millions of dollars. It is very wide and very deep and requires hundreds of thousands of documents, days and days of questioning, of discovery, multiple, a dozen experts, and the liability is sweeping. And it will be about 160 days, probably more, of trial. So Beaver Lake knew that it was not going to have the funds to see it through to trial. And it worked very hard to fundraise. And the case received enormous international attention. And Beaver Lake received lots of donations from people across the UK and Canada and the US. Raven, maybe you've heard of Raven. It's a very well-established fundraising organization now for Indigenous rights litigation. It was actually founded specifically to raise funds for Beaver Lake's case, and it did raise significant funds, but it couldn't raise enough to sustain the litigation. So in around the strike motions ended around 2014, and Beaver Lake had some experts do some work. It started to collect some community evidence, but it realized it could not afford to continue the litigation to resolution. It was like building half a bridge. And it would cost, between 5 and 7 up to 10 million potentially to have the case heard through to trial. And so it brought a very unique application, or rare, I should say, application for what's called advanced costs. And this is a application that plaintiffs can bring if they can't afford the cost of the litigation, but the case itself is an important case to all Canadians, and it has merit, and it's considered to be special enough. So the court will look at the case and say, is this something that all of us would benefit from a resolution? And so Beaver Lake brought that application in 2018, but it was itself an enormous undertaking to bring this application. And again, because of the parties who Beaver Lake is up against, it was very, very hard fought. And essentially the issue that was being was the focus essentially became about whether Beaver Lake was broke enough to qualify for this award. So the nation had to establish that it was what the courts called impecunious, that it couldn't afford the litigation. And so Beaver Lake at that time had some resources available. And when I say some, I mean, it's laughable. It had about $2 million that it had in a trust account for its community, that it was using for community purposes to support community infrastructure, housing, water systems, and all the basic needs of the community. And so it was because it had that small amount of resources that Alberta and Canada said, well, you have to deplete that and then you can bring your application. So you have to direct all that to the litigation or not, but you can't qualify for this award unless you are destitute effectively. So we had argued this application before the case management judge at the time, Justice Brown. And again, it took about a year and a half to prepare. There were 20 affidavits. The Crown cross-examined Beaver Lake affiants, 7 Beaver Lake affiants were cross-examined. Crystal was one of them. There was 6 government lawyers at every cross-examination. There were hundreds of questions about Beaver Lake's financial circumstances. It was a complete interrogation into the poverty of this community. And it was a very devastating process for the nation. So that application got heard. The judge ruled in Beaver Lake's favor at the end and said that Beaver Lake should not be forced to choose between funding constitutionally important litigation to enforce treaty rights and the basic needs of the community. And that's what Beaver Lake was being forced to do. And so the court ordered that that funding be provided to Beaver Lake in the amount of about $600,000 a year total. And so Alberta and Canada were required to pay $300,000 each, which is, in my opinion, very modest amount of funding. And they appealed it. They said that Beaver Lake should be required to spend the money that it did have on the litigation, and that they weren't impecunious, and the Court of Appeal agreed. So they won at the Court of Appeal, and the Court of Appeal adopted their test, which essentially was a test of destitution, that you couldn't qualify. You're making choices, they called them policy choices, about whether to spend the money on housing or litigation, and that's just a choice. That was the test that was applied by the Court of Appeal. So Beaver Lake appealed sought leave, got leave granted to the Supreme Court of Canada, went to Supreme Court of Canada. The Supreme Court of Canada clarified this test on what is impecunious in the context of a government. Beaver Lake Cree Nation is a government. It needs some money to run its operations, to provide services and programs to the community, and it shouldn't be required to deplete all of those resources in favor of constitutional litigation and enforcing its constitutional rights. So the Supreme Court kind of agreed, set out a great test, basic needs test, that essentially if the nation can establish that it requires the funding for basic needs, that it ought not to be forced to divert that funding to the litigation, and it would qualify for advanced costs. But by now, so much time had passed that the court said it's still going to go back to the Chambers judge for a new hearing, because there's been a few years that have gone by, and so the new financial situation needs to be updated. And so we were back again in front of the court. And this time, Beaver Lake had to marshal more evidence, but we got expert reports. We did a gap analysis to show what the deficits were in the community, and they were outrageous. I mean, the community's needs are so significant and substantial. And so Canada actually settled the cost application, but Alberta didn't. Alberta maintained that Beaver Lake should have to use all of its money on the litigation, and Beaver Lake won at this next hearing, and the judge, Justice Bokenfour, ordered that Alberta pay $1.5 million a year towards Beaver Lake's legal fees. So that's the state of things as they stand now. And if you could just go to the last slide. It's taken a long time, as you can hear, to get to a place where Beaver Lake was actually able to advance the litigation and have the funding that it needed to do so. But over the last year and or two, it's been able to use the funding that it's receiving to significantly move this matter to trial. And so now this is a very exciting aspect, but there is a trial date set for January 2027. And I say that is exciting because you wouldn't believe how hard it is to just get something like a trial date. And the Crown has been resisting agreeing to a trial date. No, we're years away still. It's not ready for trial. And Beaver Lake has to constantly be pushing to have its day in court. And the more delay, it's the thing about the access to justice issues here is the more delay that you need. Like it's just this never ending cycle because this is a continuing infringement claim. The infringements continue. So every year that goes by, we have to collect all the evidence from that year, including anything that the Crown has done in that year. So it is quite remarkable to see that this case, by the time it gets heard, the most of the record, the documents, the questioning, the trial is going to deal with things that happened after it was filed in 2008, which is, just again, just that is to say, if this case was heard in those first 5 years, it probably would have been a few months long. But now we have 17 years of a record to contend with as the Crown will try to establish that they're addressing this issue, that they have mechanisms in place to deal with it, and so it just keeps the longer it takes, the longer the trial. So we're doing everything we can to stay disciplined, to keep things tight, but it's difficult. There's applications that are being brought to constantly expand the scope of pre-trial discovery, and so we're just contending with that. But if Beaver Lake wins this case, or as my clients say, when we win, it will be a game changer and be very significant. There'll be declarations about the meaning of Treaty 6, declarations of infringement, declarations of no more development until the government addresses the infringement and consults using a consent-based model with Beaver Lake, compensation and damages for diminishing culture and way of life from development. So practically speaking, a win will give Beaver Lake control over the development in its territory. And so that it can do the hard work of restoring the lands to a place that will allow for the meaningful exercise of its rights. So I'm going to hand it over to my dear friend and client, Crystal. Now she's got some remarks to make as well.
Atam skatuan kakiao awiak Crystal Lameman sigas wanam sage kani hiopiagoskan ustisama yosiwin gutasiko utinia. So greetings to each and every one of you. I'm Crystal Lameman, member of the Beaver Lake Cree Nation here in Treaty Number 6. I think that Karey's final comments about, what a win looks like for the Beaver Lake Cree Nation is not just a win for the Beaver Lake Cree Nation. It's a win for everyone who cares about this place that we call home, and this place we call home in its entirety, all of Mother Earth. And AWA has been a supporter and an ally for many, many years with the Beaver Lake Cree Nation. We have stood side by side in many of the challenges that actually even my colleague Karey isn't aware of. And so I was contemplating, what I was going to say, and actually one of the reflections I had as Karey was speaking, and as I thought about the allyship that the Beaver Lake Cree has with the AWA is with regard to the protection of the caribou, and how the AWA has helped to lead that charge. And many of you who are deep in the trenches of that work may or may not know about Alberta's recent decision to amalgamate the Wandering River Subregional Plan and the Cold Lake Subregional Plan, which was a completely arbitrary decision that totally ran over our right to free, prior, and informed consent, our right to say yes or no. But at a bare minimum, it ran over exactly what Karey started the talk with, and that was the duty to consult. The very basic process that has been established. And so Beaver Lake is heavily involved in that process right now, and trying our best to ensure that we put on the record the interventions around this amalgamation and what it is they are attempting to do. And so I think that in as I was thinking about, what I wanted to share, I think that it's important in these conversations that we have, and I've stood in many of these positions where, we've shared the history of Beaver Lake's case. One thing that we have failed to do is take the space and the opportunity to share knowledge and understanding of treaty making and entering and the rights that we affirmed. And so I'm going to share a little bit about that, because I think it's important, and I think this is a good opportunity to do that, especially in light of the great job that Karey always does, giving that high level overview of Beaver Lake's case. And so, by the end of treaty making, First Nations people, and then after treaty, became accepting of the fact that we were now also treaty Indians. We had confirmed and affirmed, basic collective rights. And some of those basic collective rights includes, but are not limited to, the fact that First Nations people and treaty Indians have sovereignty. Our peoples can act within our own authority as derived from our Creator. We have complete jurisdiction over all matters that pertain to our peoples, our lands, and our territories, and that we can enter treaty with other nations, that there are collective rights of individual nations, and that we have internationally recognized sovereignty. We have rights to land, air, and water, and we talk about that, but I think oftentimes we forget to define or say what that means. And so we have the right to steward and occupy our lands and territories, including all natural resources. And we possess historical continuity to our lands and territories. And we've had that since time immemorial. And we have the obligation to protect the land and live in harmony with
in a world that can often feel really heavy.
And that we are the keepers of these lands for our generations to come, those unborn generations. We have spiritual beliefs, customs and traditions. We have our own languages. We have self-determination, and that includes natural laws, so the laws that we've been given by our Creator. We have our own, as individual sovereign nations, our own laws and customs. We have our institutions of governance. We have justice systems, and even within that, we have our own forms of law enforcement, as an example. And so we have these rights, and our knowledge keepers hold that understanding and pass it along, and we live it out in our nations. We live it out in our nations every day. But colonial governments have tried to undermine our rights since the time of treaty making. And in treaty making, we negotiated, and again, not limited to, but we negotiated the medicine chest clause, universal health care. We negotiated the famine and pestilence clause, which protected us just recently during the COVID pandemic. We negotiated education and agriculture and economic rights. And so we understand that there may not be a shared understanding of what rights we as treaty Indians have. And so, you know, by describing our most fundamental rights, the inherent rights, the rights that our people are born with, the right to air, to water, to land, to natural resources, to governance, our spiritual ways of knowing, being, and doing. These rights have been practiced since our Creator placed us here on this land, and well before the arrival of our visitors. And these are collective rights that flow from our bloodlines, continued relationships to our home territories, and are distinct to the practices of each nation. And so those inherent rights that we have are not granted by some external authority, such as colonial governments like Canada or Alberta or the United Nations. And they can't be taken away because they are the very rights that we are born with. And I think it's important to talk about that in light of everything that Karey just said, because I think many times we simply just state this, but we never actually describe what we mean. And so even thinking about and contemplating treaty making. And so when our visitors arrived, there were many processes of treaty making within our nations. And that even includes making treaty with our air, land, and water kin. And in the Maritimes, in the 1700s, there were the peace and friendship treaties, which are still in place today. And those peace and friendship treaties were not surrenders or land transfers, but agreements between First Nations people and settler peoples to live together and share the land. And so the same can be said about the numbered treaties, treaties 1 to 11, which spanned from around 1871 to around 1921. And they spanned from Ontario, across the prairies, and into the Northwest. And it's where the Beaver Lake Cree Nation, to which I belong to, entered Treaty 6 in 1876. And so when First Nations entered treaty, they did not give up those inherent rights that I just named. In fact, First Nations were assured, just as Karey said, that the treaties affirmed their right to self-government, to self-determination, and to live and exist as a sovereign peoples on their lands and with their resources. And First Nations were promised they would live as they did the day before treaty making, and that what was offered in treaty making was put on top. First Nations never interpreted the making and entering of treaty as a releasing, ceding, or surrendering of their lands, territories, and or resources. Through the making of treaty like Treaty 6, the Crown made many promises to our peoples. And so I'll say, for example, in Treaty 6, the medicine chest and famine and pestilence clauses. So in exchange for the use of our lands to the depth of the plow, these promises the Crown made are what now are called these treaty rights. Minerals were never put on the table for discussion. That's something that we fail to discuss as well. So we never relinquished rights to our water, to our minerals, even to the Rocky Mountains. And so it's not so far-fetched to say that those were illegally taken from us. And you hear it in the historical language. Alexander Morris, the treaty commissioner who negotiated a number of treaties, including Treaty 6. So in those negotiations leading up to 1876 and Treaty 6 agreement, promised that First Nations could continue to hunt, fish, trap, and gather while continuing our land-based way of life into an indefinite future. So no endpoint was ever discussed, which is clear in the treaty text: as long as the sun shines, the grasses grow, and the waters flow. So the spirit and intent of the treaty was made clear by the Crown's treaty commissioners themselves in the treaty-making process. And so as Commissioner Morris said in 1876, what I have now, or what I have offered, does not take away your living. You will have it then, so after treaty, as you have now, and what I offer now is put on top of it. Through treaty, then First Nations added new negotiated rights on top of their inherent rights. And so we have these rights, and Indigenous knowledge keepers hold that understanding and pass it along, and we live it out in our nations. But we continue to face these continued infringements and encroachments into our territories with this understanding of ownership, and that we gave up. And we simply know that that isn't true. And so we know that through things like the 1930 NRTA, which illegally transferred our resources to the province. And that's strategic, because they then limit how much and to what extent rights are considered in their actions and what they have to do to accommodate any impacts to rights. And so that's led to a lack of proper consideration and protections of inherent and treaty rights. And I never really quite understood that until I had to live it through this work. And now I know for certain, and I stand on that, that's in fact true. And so that transactional understanding of treaty by settlers suggests that First Nations ceded and surrendered title to the land to the title to the land to the Crown in exchange for this fixed spectrum of rights and entitlements. And this colonial mythology about treaty facilitated both settlement and capitalist pursuits. So access to valuable natural resources through such acts that followed, like that illegal NRTA. And this interpretation of treaty provided a narrative of the peaceful absorption of treaty Indians into the colonial state. And so this issue of whether our peoples gave up their rights to the land is one of the most highly contested issues of treaty interpretation, and something that we're now beginning to explore in this litigation. And so, we are looking to, things like the report of the RCAP, 1996 RCAP. And so in there's a direct quote that says, it's highly probable that no consent was ever given by First Nations parties to that result. Our peoples who believe the Creator set us on our traditional territories and gave us the responsibility of stewardship of the land and of everything on it are not likely to have surrendered that land knowingly and willingly to strangers. So treaties were regarded as land use frameworks and agreements for sharing the land and mutual coexistence. Those by virtue of the imperial crown did not receive anything but instructions on how to share and live peacefully with my peoples. Yet Canada and the provinces claim to own and have jurisdiction over nearly everything in and on these lands and have conducted business in that way. Again, for example, implementation of the NRTA. And so to which we continue to ask, well, where is your bill of sale? And I know that many of you have probably heard that along the way. And then I hope that as allies, you'll continue or at least pick up that language and start asking, when you sit across those tables, if you do, where their bill of sale is. And so, that phrase, death by 1,000 cuts, can be used to describe the government's current and historic approach to our peoples, their rights, and the land. And there's limited consideration to cumulative effects and how one specific activity and its effects will interact with surrounding activities and already present effects on the lands and resources and cumulative impacts to inherent and treaty rights, which is the biggest question that we are up against and continuing to prepare for. And the government's current definition of inherent and treaty rights is narrowed to only include those subsistence rights, hunting, trapping, and fishing for food. So other critical aspects of my nation's inherent and treaty rights are then placed under this umbrella term traditional uses and are not considered to be rights. This narrow view of inherent and treaty rights allows the governments to reduce its accountability and requirements to protect and preserve our rights. And so we're really in this time right now where we're really contemplating and thinking about and reflecting on and strategizing and developing and talking and seeking the knowledge from those who know, our elders and our knowledge keepers or land users, discussing that that intentional return to treaty and that intentional recognition of sovereignty. And so, we continue to hear the calls from Indigenous movements for things like land back, the land back fight, and that's consistent with assertions of sovereignty, which have been ongoing since contact. And so we've long struggled to get Canada to recognize and implement our sovereignty and our authority over our lands and our nations, and to repeat, these are our inherent rights that were affirmed and added to in the process of treaty making. Yet Canada and the provinces have failed time and again to implement the treaties and respect our rights. And my peoples face a myriad of disadvantages due to the theft of our lands and resources and the continuing attempts by successive governments to deny us of our lives, our children, our culture, and our lifeways, our way of life. And so, we are in this place where we feel a sense of, despite the struggles and the trials and the tribulations, we're in this place where we are creating and developing this system built for us, by us, and that serves us. And that we don't need to be assimilated into Canadian society and laws. In fact, we ought not to be if we are upholding everything that I just said. And so none of this is possible without, those inherent and treaty-based frameworks at the forefront of the advancement of our sovereignty and self-determination. And so as we continue to move away from these systems that support unequal power relationships and threaten our rights, and we continue to stand up in this fight, this challenge that we have, I think that if there's anything I want to say, it's that this is not just for the Beaver Lake Cree Nation. This is for all human beings. It's for all life. And so I would say that in closing, when the trial comes in 2027, and even in the lead up to it starting next year, you know, we call on our allies and our friends and all Treaty Indians to stand with us. You know, the courts will be open. Come, sit with us, be with us, pray with us. Come to Beaver Lake and sit in that courtroom that we're building and developing. And so, you know, as we continue to stand side by side with AWA in some of those policy decisions and tables, you know, we also ask you to come that time when we're at trial and come and be with us. And so with that, thank you, Carolyn. Thank you for always supporting us and standing with us and never forgetting about us. You know, sometimes we get quiet in the back just doing the work, but Beaver Lake's case is still ongoing. We're still fighting, and we're still doing this for everyone, and we hope that you'll all join alongside of us. That's it. And look at us, Karey, we still have 5 minutes left. I'm just gonna wait for AWA if you can unmute there and take back control. Is somebody going to step forward?
Sorry, Cliff, do you want to go ahead?
Yeah, I didn't know if somebody else was up. Thanks for that. Yeah, the long struggle. And I just have a great deal of empathy for it. And so, I mean, it doesn't get much publicity. And I often wonder about that, right? Because it's such an important case. And I think it's going to have ramifications. Like I always wonder why such cases weren't brought in the grasslands. Because if anywhere treaty rights were totally abrogated, it was, you know, the privatization of land, the continued sale of public lands without any consultation, including recently 24 sections that the MD of Tabor Council voted to convert to, that's municipal public land, native grassland, to convert to irrigated agriculture. So, you know, I think, you know, we have to work in these colonial systems in some ways, but they hold us back, right? And I think that was really reflected in what you had to say, but it's kind of the only game in town. It's just, it shouldn't be this hard.
I don't know who the chair of the meeting is. Can one of you step forward, please?
Sorry, we didn't realize we were on mute this whole time. We were just checking, there is a question in the room here, so we'll just go ahead and let you ask that.
Will they hear me?
Yes, so this,
Crystal, Karey, I'm kind of relatively new here, and so I appreciate the chance to listen to it. It's been very helpful. I'm a professional engineer who has worked in oil and gas, and I've become interested in the issues of Indigenous rights and treaty rights. I'm planning to stand for the governing council of my regulator, the Alberta Professional Engineers and Geoscientists Association, also known as a PEGA. And I'd like to try and go to the council to be elected, partly with a mandate to address environmental infractions on Treaty 6 peoples. And I need some help. Every time I approach people in Treaty 6, I never hear anything back because I think I'm an old white guy with a beard, and that's not something that people see much of. So I wonder how I may get help, maybe through Caroline. I can re-establish contact after this meeting. That wasn't a question.
Karey, I can jump in there. I guess it depends on where you're reaching out in Treaty 6. I wouldn't say much more than that, but yeah, you could. I don't mind, Carolyn. You can share my email, and we could have a brief conversation. I can't promise anything, but I also can't promise that I'll have a ton of time either. We are preparing for trial now. We're still in the discovery process and questioning and all of those fun things. But I absolutely could try to connect you with some folks.
Yeah, thank you. I'll reach out to Carolyn, who I know.
Yeah, thanks. That sounds good.
Yeah, thank you.
I have a question. Thanks so much, Crystal and Karey. Can you give us a sense of what, the next year is gonna look like? What are the main things you're thinking about in terms of, like, it still sounds like a real endurance test. And can you give us a bit more feel for what you still have to achieve in that time?
Sure, I'm happy to answer that. It is it is an endurance test. It's like running a marathon at a sprint. So, we do have, even though there's a funding order and there is more funding now, it's still, our team is lean and everyone is working pretty much flat out on the case. The pre-trial steps, so before you get to trial, for those of you who may not have any experience in that world, there's a phase before trial called discovery, where each side gets to learn about the case of the other side. And so that involves two things. You can write questions out, and those are called interrogatories, or you can ask questions orally of different witnesses that will have material evidence at trial. And Alberta actually has, more than any other jurisdiction in Canada, the most generous discovery, pre-trial discovery regime. And so we've had now something like 27 days of oral questioning, where Crystal, on behalf of Beaver Lake Cree Nation, has had to sit in a room and just get pounded with questions from the Crown lawyers. And we've had an opportunity to do the same of their witnesses, but then they want to question more witnesses and more members. And so there's been applications about the breadth and scope of their ability to question members of the community. That there's been applications to deal with that, and whether the questioning process is proportionate. We're actually going to an appeal later this month on the judge restricted the scope of discovery rights for them and said they could not question every single member on their oral history information. And Canada is appealing that. They want to be able to go into the community and ask members questions under oath. So it's just like this. So you can get bogged down really easily into this pre-trial discovery phase. So we're there. We're also have retained a number of experts who are writing anywhere from 50 to 400 page expert reports on a whole range of matter, the historical issues relating to the treaty, both from the Indigenous perspective and just what the historical written record says about the treaty. There's experts who are giving evidence about the level of disturbance in the area. There's experts who have interviewed the community and are going to be giving evidence about anthropologists, about the way of life. There's going to be some archaeological evidence. There's wildlife experts talking about the the abundance or lack thereof of various wildlife species. So we're working with all of these experts to help get their reports organized and in a court ready way. And then another huge, enormous task that we have ahead of us, which we'll enjoy, but we'll be working with the community to identify who will be giving evidence from the community, and then spending lots and lots of time sitting with elders and talking to them and preparing them and getting them ready. And then we're thinking deeply and thoughtfully about how to hold this trial in a way that will bring dignity to the community, that will be culturally sensitive, that will be culturally safe, and trauma informed, and what kind of adjustments and modifications need to be made to not only the physical space, but also the way that these trials are run. So we're thinking a lot about that. So those are just a few things that we have on our plate in the next year as we get ready for trial.
Any other questions in the room or online?
Can I just follow that up, Karey? Can you talk a little more about, and Crystal maybe mentioned it, will there likely be some of the trial held either on the nation's reserve lands or in Lac La Biche?
There has been agreement from the court to have the community evidence heard in the community, and we're now trying to figure out how to create a physical space that will allow for that. The infrastructure, as I mentioned earlier, in Beaver Lake is not in good shape, and so while the court has been amenable to moving its operations to the community, we still have a lot of work to do on figuring out logistically how to do that. But that's a really important thing for the community and speaks to this issue of cultural safety. So, but yeah, that's the intention.
And
Thanks.
there will be, Karey, if I'm not mistaken, will there be any hearings in Edmonton?
So the trial, yeah, we're just finalizing the trial schedule. The trial in theory would be heard in Edmonton in the court there. So there'll probably be some portion of it that will be held virtually, which would make it more accessible for people like yourself too, if you're interested in ever watching any of the evidence. But those kind of things are getting worked out.
And I would just say to watch Beaver Lake's website, and there's a tab dedicated to the treaty claim. And so I am actively in the process right now of updating and revamping that section as we get closer to trial to ensure that updates are clearly visible, and so that you all know what's happening. And there will be call outs, I suspect, in the next year, fundraisers, those kinds of things, to just bring some energy back into the case and have more public education around and awareness around Beaver Lake's case.
Thanks.
I have a question.
Sure.
I'm assuming that further disturbance is continuing, and forestry and oil and gas and linear disturbance. And so none of that work is halted at this stage. And am I right to think that?
That's right. Yeah.
how do you hold, apart from the anger of seeing, with all this long time, yeah, that must be very difficult in the community, in essence. I'm very happy to hear you're trying to turn the trial into a community building and healthy experience for the community. That's really important.
Yes, thank you. Yeah, thanks for that comment. And certainly the ongoing infringements are vexing and difficult, and we raise those before the court in urging the court to take a very disciplined approach to getting this matter to trial.
I think especially in the current political landscape, you all are aware of, the different bills and legislation and policy decisions that are being made right now. And those are all a part of Beaver Lake's litigation. And so they're not things that are not going to be addressed. And I would say confidently that, as Beaver Lake continues to win these appeals and different things that we come up against with Alberta and Canada, and in thinking about strategy, it is Beaver Lake's case that a lot of this rests on, and it's no wonder why they are aggressively continuing to try to ensure that the case isn't heard. And so we are really setting precedents here for environmental protection and on standing on treaty rights.
There's a question over there too.
Yeah, I wonder, is there a venue or a place or a time where people with interests in this can come together to hear about progress being made across Alberta, BC, Canada? Is there such a thing?
That's a good question. I'm not sure if any Crystal or Karey have an answer to that, or Carolyn, I don't have the answer to that, unfortunately.
June, you're
Raven,
talking about indigenous legal claims specifically? Or
Well, it would be that, right? It would be things like economic development. It would be things like development of technology. It'd be very wide. For example, in the United Nations, we have the Conference of the Parties in Climate Change, right? Huge thing. Do we do anything like that at a regional level with the Indigenous nations? Is there such a thing?
Treaties 1 to 11. We actually have, it's not something that's open to non-Indigenous people, but it is the question you're asking. So I will say that we do have a advocacy body that spans across treaties 1 to 11. And it is comprised of all the nations in treaties 1 to 11. And we meet once a year. We have a big conference once a year, a big gathering rather, where we discuss all of those matters. I think that it would be great if that existed as kind of an open forum for all peoples who are of the same mind. I don't know of any.
How could that be done? Where would you start?
AWA can do it.
yeah, I was going to say Raven is a good source of information about some of these cases going on, but yeah, you have to go in the alternate media, eco-justice, AWA. I mean, that's why I say it would be good if the mainstream media, but in terms of getting Indigenous people to sit down, I think it's always on a case-by-case basis and be very respectful of their time. because they are way overburdened. And so our role is to support and, tell us what you need from us. And I'm sure we'll be there.
Thank you very much.
I
Thanks
agree.
everyone for your interest too. Really appreciate the opportunity to be able to speak with you tonight.
Let's go front. I just wanted to say thank you to our speakers for the wonderful evening. And thank you to everyone for coming out tonight, both in person and online, and spending your Monday evening with us and supporting organization, but of course, the bigger issues at play here in the presentation. I'm Jill. I'm also an outreach and communication specialist who will be covering for Amy pretty soon. So you'll be seeing more of me at these talk events. And I just want to say last couple closing remarks. Some of you may know with 2025 is our 60th anniversary of the Alberta Wilderness Association having a voice for Wild Alberta. And whenever people come to our talk nights, I always like to remind you, encourage you to continue to be a voice for the environment and advocating for these protected areas and protesting inappropriate land uses. Some of the ways we can do that is upcoming further interactions with the organization. We have another similar talk night coming up in October on the 16th, where we'll be doing a book reading with a longtime biologist and friend of AWA, Lauren Fitch. There are details on our website similar to where you would have found the login information and registration for this event. And then on November 14th, that is actually going to be our annual kind of lecture and awards night. Bigger deal than usual because it's our 60th anniversary this year. So we're moving to a bigger venue down at the Crescent Heights Community Hall, and we'll be joined by Cor Blund, the country music star, as our keynote speaker for the evening. And we're excited to have a bigger crowd for that event to kind of really can integrate with the community and acknowledge the 60 years. Tickets are still available, also on our website. And that's really it. I just wanted to thank everyone again for coming out tonight and hope you have a great evening. And thank you again to our speakers.
Bye everyone. Thank you.
Thank you.